guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, we have new documents on the Orange County Clerk's website for Tommy's case. They just posted yesterday, so we're going to go over them. And I've only glanced at them, so again, as a lot of times, we're going to basically be going over them together. So let's jump right over to the Orange County Clerk's website. All right. Again, this is a website that we have become very familiar with. Let's see. And we're still on appeal. You can see here on the top, the motion was filed for defendant's brief on the relevance of state's hearing Exhibit 8. That's 11 pages long, so we're going to read that first, and then there's a state's response to that. So here is the first filing from yesterday. As you can see, it was e-filed at 4:21 p.m. yesterday, so really most people haven't seen it till today, the 24th. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus William Thomas Zeigler Jr. All right. Defendant's brief on the relevance of state's hearing Exhibit 8. 1. Introduction. This brief addresses the limited use of whether and in what ways evidence and testimony from Mr. Zeigler's 1989 resentencing hearing, which has been admitted as State's Hearing Exhibit 8 in these proceedings, has any bearing on Mr. Zeigler's motion to set aside convictions based on newly discovered evidence. The short answer is that the character and other evidence presented at the resentencing hearing has little to no bearing on the instant motion. Much of the evidence presented at the resentencing hearing involved Mr. Zeigler's character and his behavior as a prison inmate, which the court found was exemplary. The court heard evidence that Mr. Zeigler was an upstanding member of his community with no significant record of crime or violence before 1975. That evidence mirrored what the defense presented at trial, all of which tends to call into question whether Mr. Zeigler, beyond a reasonable doubt, went from an upstanding non-violent citizen to a mass murderer as the state contended. However, the focus of the 1989 hearing was not on guilt, the central issue on this motion, but on aggravating and mitigating sentencing factors which are not relevant here. One aspect of the resentencing hearing that does have some relevance is the state's characterization of the trial evidence. In particular, the state at resentencing again emphasized that 1. Mr. Zeigler shot at every one of his relatives at close range. 2. Mr. Zeigler struggled with and repeatedly beat Perry Edwards in addition to repeatedly shooting him. And 3. Mr. Zeigler's jury deliberated his guilt for 3 days, but deliberated his sentence for just 5 minutes before unanimously rejecting the death penalty and recommending a life sentence. The court can consider that evidence in assessing 1. The extent to which the new evidence adduced at the December 2025 evidentiary hearing undermines the case the state presented to the jury, and 2. How much additional evidence would have been needed to, quote, tip the scales, unquote, to reasonable doubt of guilt. The 1989 resentencing hearing demonstrated that the jury was very close to finding reasonable doubt in 1976, and that it would likely have found reasonable doubt had it heard the newly discovered evidence that has since been adduced. However, the court has already been presented with substantial evidence on these points and need not consider the 1989 resentencing record to grant relief here. 2. Summary of State's Hearing Exhibit 8. Mr. Zeigler's jury deliberated for 3 days before returning a guilty verdict. State's RG'd Exhibit 8 at resentencing hearing transcript RHT 13, 3-8. The same jury reached an ununanimous decision to reject the death penalty on sentencing in just 5 minutes. One juror, Irma Brickle, stated in open court, quote, "I still feel he's innocent," unquote. Trial transcript at 2838, 11 through 12. Quote, I still don't feel like he's guilty, unquote. ID at 2841, 19 through 20, and that she ultimately voted to convict Mr. Zeigler because, quote, at the end, I was pressured into it and I just couldn't take it anymore, unquote. The trial judge overrode the jury's sentencing recommendation and sentenced Mr. Zeigler to death. In 1988, the Florida Supreme Court vacated Mr. Zeigler's death sentence and remanded the case for resentencing. Zeigler versus Dougler, Florida 1988. The Supreme Court further directed that, quote, because the jury has already rendered an advisory verdict of life imprisonment, the new sentencing proceeding need only be conducted before the judge, unquote. On resentencing, the same sentence was reimposed. Zeigler versus State, Florida 1991. The resentencing hearing included testimony from a number of witnesses, including approximately 11 character witnesses who generally testified to Mr. Zeigler's good character and history of good deeds. And it's quoting a lot of exhibits and numbers there, so we're not going to read all those. The court accepted the state's evidence as to certain aggravating factors, principally that Mr. Zeigler had been convicted of multiple murders and that the jury had convicted Mr. Zeigler of committing 2 of the murders in the first degree. The court agreed with the defense as to certain mitigating factors, finding, among other things, that the defendant has no significant history of prior criminal activity, and that testimony indicated the defendant had participated in community projects, specifically one to beautify the downtown area of Winter Garden and a committee to explore racial tensions and minority housing in the Winter Garden area, that Mr. Zeigler had a good prison record and was an asset as an inmate, and that the testimony reveals no propensity for spontaneous violent conduct in the future. A. Evidence bearing on the centrality of the physical evidence and juror uncertainty bordering on reasonable doubt. The 571-page resentencing hearing transcript that is part of the state's hearing Exhibit 8 bolsters the existing extensive record of how central physical evidence was to the state's case and how substantially the newly discovered evidence undermines that case. With respect to Eunice Zeigler, the state argued, quote, the evidence shows that the defendant walked into the store with his wife, walked into a back office, that he took one of these, what he thought were stolen guns, as Eunice Zeigler removed her coat, placed this gun to the back of her head and shot her dead, unquote. Were this true, Mr. Zeigler would have been covered in Eunice Zeigler's back-splattered blood, since her fatal gunshot produced an entry wound only, but no exit wound, with spatter evident on the wall and door frame of the kitchen in which she was killed. No such DNA was present anywhere on any item of Mr. Zeigler's clothing. With respect to Perry Edwards, the state argued that, quote, the evidence shows that at the point there was a struggle between Thomas Zeigler and Mr. Edwards, his father-in-law, that during that struggle, Mr. Edwards was shot twice with a different gun, unquote. The state continued that Perry Edwards, quote, was also beaten in the head and eventually succumbed to these injuries. He was given, by my count from the record, 17 separate blows with a blunt object, the evidence indicating that object being this, which was a crank for a carpet or linoleum roller, unquote. And again, the state argued that Perry Edwards, quote, was struck, I count, approximately 17 times, beaten 17 times by this kind and gentle man. Again, Perry Edwards was beaten severely, viciously by Mr. Zeigler, unquote. Mr. Zeigler would have been covered with Perry Edwards' blood had he committed these acts. The fact that he was not establishes reasonable doubt as to Mr. Zeigler's guilt. That is especially true because the state now concedes that the evidence is not consistent with Mr. Zeigler struggling with Perry Edwards at all. December 1st through 5th, 2025, evidentiary hearing transcript. The state reiterated its claim at the resentencing hearing that the evidence proved the sequence of killings occurred. State's RHG Exhibit 8 RHT 925 through 1017. explaining how at that point, once Perry Edwards was dead, the evidence shows that Virginia Edwards had crawled to another portion of the store. He fired one bullet into her head and killed her. And now Mr. Zeigler now has 3 bodies in his furniture store, all of them dead, all of them shot or beaten to death. The second stage of Mr. Zeigler's plan comes into effect. Charlie Mays arrives at the store. Now, with the benefit of DNA testing, the state's expert conceded that it is not possible to assign a sequence to the killings. Finally, the state also confirmed and indeed emphasized that the jury deliberated Mr. Zeigler's guilt for 3 days before ultimately finding Mr. Zeigler guilty, but deliberated his sentence for just 5 minutes before unanimously rejecting the death penalty and recommending a life sentence. B. Evidence regarding Mr. Zeigler's character and prison record. At the resentencing hearing, Mr. Zeigler presented substantial evidence regarding statutory and non-statutory mitigating factors relevant to sentencing. Before Christmas Eve 1975, when Mr. Zeigler's life changed forever, he was an upstanding member of his community. His reputation extended throughout his town, a neighborhood afflicted by segregation and relaxed tension, and a church of 1,000 members. Mr. Zeigler stood out as the best entree the pastor could have at that time with the black community. He kept active and involved, beautifying local streets and helping fellow businesses because he, quote, was proud of the town, unquote. As of 1989, Mr. Zeigler had 0 violent disciplinary infractions. He had almost no infractions at all. The only remarks on his record received from possessing an illicit heating coil for making coffee, a dismissed infraction for having too many prison canteen coupons, and an infraction for an illicit screwdriver he used to fix his glasses. He never attempted to escape. Even when his father died and Mr. Zeigler hadn't been able to see him for months and could not attend his funeral, he processed his grief through writing a piece he titled Helplessness. An institutional counselor testified that Mr. Zeigler was an exceptionally model prisoner. The court found that Mr. Zeigler had an outstanding prison record and adaptation to prison life. The court held that Mr. Zeigler does have a good prison record and appears to have adapted well to prison life and is an asset as an inmate. C. Irrelevant and unreliable evidence from another inmate. At the resentencing hearing, the state presented testimony it argued was relevant to sentencing from another inmate with a long history of criminality, Eddie Odom. Odom testified that Mr. Zeigler had for a time agreed to participate in a plot engineered by Mr. Odom, whereby Odom would have another inmate claim to have committed the murders for which Mr. Zeigler had been convicted in return for money. Mr. Zeigler did not dispute that, out of desperation, he went along with Odom's plot for a time before declining to continue. It was undisputed that Mr. Zeigler did not ultimately pay anything, and the plot did not proceed. Mr. Zeigler explained his state of mind at the time candidly, quote, "I wasn't guilty of it and it seemed to be the only hope I had. That's not a very good answer, but that's the truth," unquote. Odom's account, to the extent it differed from Mr. Zeigler's, was heavily impeached at the resentencing hearing. The Odom evidence was sufficiently unreliable that neither the trial judge nor the Florida Supreme Court mentioned it even once. The evidence showed that Odom threatened Mr. Zeigler, had him attacked, coerced him into an elaborate scheme, then attempted to extort him. Mr. Zeigler went along for a bit, which he fully admitted, but then refused to comply. Mr. Odom then reported the scheme, his own scheme, to law enforcement in exchange for a significant potential sentence, commutation, and promise of support of clemency. As a jailhouse informant on death row, Mr. Odom had tremendous incentive to influence Mr. Zeigler and use the situation to his advantage. See State v. Bowler, Florida, 1st DCA 2019, affirming grant of new trial when the verdict was against the weight of the evidence, in part because of a witness's strong incentive to obtain a sentence commutation. Floyd v. State, Florida 2005, reversing denial of post-conviction motion and ordering a new trial, in part when the state had withheld evidence of details with the jailhouse informant. State versus Mango, Florida 2023, collecting cases. Odom was notorious for drug dealing on death row. He was a powerful and connected inmate who could obtain any illicit item he wanted from the prison kitchen. And he had arranged for Mr. Zeigler to be attacked in prison. Odom had experience across local jails and state and federal prisons in Florida and Alabama. He knew all about Mr. Zeigler from detective stories and from Odom's wife, who was friends with the court reporter at Mr. Zeigler's trial. In fact, Odom turned over to this wife's materials relating to the plot to have another inmate claim responsibility for the murders a year or two after they were created. She only provided them to the state attorney when facing her own unrelated criminal indictment, for which she was looking to cut a deal. Both Odom sought to take advantage of the information, and Mr. Odom's sentence was commuted to life in prison shortly after the time he attempted to scheme with Mr. Zeigler. He also got a promise of clemency support from the state attorney in exchange for his testimony. Gee, what a deal. 3. Legal standards. In evaluating a post-conviction motion, the court must consider all evidence the jury heard, the evidence the jury should have heard, and evidence the jury would hear at a new trial. Swofford v. State, Florida 2013, Hilden v. State, Florida 2014. This post-conviction analysis is to be holistic, and it includes evidence discovered after the trial that would be admissible at a new trial. Swofford in Robinson v. State, Florida 2000. The standard focuses on the likely result that would occur during a new trial, with all admissible evidence at the new trial being relevant to that analysis. That's referencing Swofford. But holistic does not mean a boundless free-for-all alleged conduct and rumors. Alleged conduct by a defendant years following the trial, whether good or bad, is irrelevant and has no bearing on a motion seeking vacatur of a conviction. 4. Relevance of hearing Exhibit 8. Evidence presented by the state in Exhibit 8 has no bearing on Mr. Zeigler's guilt and accordingly has no bearing on the motion currently before the court. Mr. Zeigler's temporary willingness to discuss a plot to have another person claim responsibility for the murders was an act of desperation. In addition to being understandable, it is also irrelevant. Evidence of Mr. Zeigler's conduct after 1975 has nothing to do with whether there is reasonable doubt as to his guilt. The remaining evidence in State's Hearing Exhibit 8 has little to no probative value. Evidence of Mr. Zeigler's good character and lack of violent history is generally consistent with innocence, not guilt. But the court already has substantial such evidence in the record before it. 5. Conclusion. State's Hearing Exhibit 8 does not alter the analysis of the cumulative new evidence adduced since his trial. Defendant respectfully requests that the court grant his motion to set aside convictions based on newly discovered evidence. Respectfully submitted, Ralph V. Hadley III, and of course the rest of the defense team. So that is the defense's motion. All right, buckle up. Now we've got the state's response to this. Again, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus William Thomas Zeigler Jr. State of Florida's response to order directing further written briefing. The State of Florida submits its response to this court's order permitting further briefing on the resentencing hearing conducted on August 14th through August 17th, 1989. The state offers the following argument. Summary of testimony. During Zeigler's resentencing trial, Eddie Odom testified that he met Zeigler while housed in the Duval County Jail. Then both he and Zeigler were placed on death row at roughly the same time. 1989, and that's referencing the trial notes there. Odom indicated that Zeigler initiated the conversation about the murders. 1989. Odom also testified that in 1977, Zeigler admitted that he killed Eunice Zeigler because He was having problems with his wife, that she was going to file for divorce, and that he felt she was going to allege she was involved in some kind of homosexual activity with somebody. She had wrote a letter to somebody saying she was going to start divorce proceedings and ruin his name in the community and all this. He had a large insurance policy on her or things like that. Yeah, that's the rumor that came out about that. Odom also provided extensive testimony about how Zeigler engineered a plan to bribe another inmate, Daniel Thomas, into confessing to the murders. This scheme started when Zeigler informed Odom that he wanted to get Daniel Thomas, one of the original ski mask bandits, to confess to the murder because Thomas had been a person of interest in the initial stages of the murder investigation. Eventually, Odom got in touch with Thomas through a proxy. The scheme then progressed over the course of several months, with Zeigler writing multiple letters about how the murders were committed. Thomas asked detailed questions, and Zeigler would answer them so that they could make Thomas's confession seem believable. Odom even wrote a letter outlining Daniel Thomas's planned confession, see State's Exhibit 9, which included relatively accurate details about the murders. The scheme fell apart, however, because Zeigler could not come up with the money to pay Thomas and Odom. As he did at trial, Zeigler took the stand during his resentencing hearing. Zeigler punctually denied that he ever confessed to murdering his wife. He did, however, admit to participating in the conspiracy to have Thomas confess to the murders. He also acknowledged that he wrote some letters to Daniel Thomas to answer questions about the murder. And let's read this. Here is the footnotes, but let's read this. The letter also includes the following line, quote, "There was a trench coat, tan in color, taken that night, probably worn to cover blood on the person involved. Coat was torn on bottom lower tail, small patch, illegal scratch out, torn spot." Resentencing State Exhibit 9. This letter was obtained approximately 14 years before Zeigler ever moved to conduct any DNA testing, and decades before Zeigler ever developed his backspatter theory. There was no need to fabricate an explanation for any DNA results. The state even argued at the resentencing hearing that the blood on Zeigler's clothing was proof that Zeigler beat Charlie Mays. The letter also indicates Mr. Mays and Mr. Edwards were beat in the head with a pipe that was 2.5 feet long, about 2 inches in diameter. The instrument used to beat Mr. Edwards was never confirmed. Zeigler even admitted that he would have followed through with the scheme if the price had been right. When asked why he would participate in such a scheme if he was innocent, Zeigler replied, quote, "It seemed to be the only hope he had," unquote, of getting his conviction overturned. You know, I can understand that. It's desperation. I don't believe he ever confessed to murdering his wife and his father and mother-in-law. I don't believe that, of course, but I don't believe that. Well, he's being honest here. He said, yeah, I was trying to do this because he was desperate. I mean, look at this. He's admitting to this. So I believe he's telling the truth. Nevertheless, Zeigler struggled mightily to downplay his role in the conspiracy, claiming that the whole operation was Odom's idea. Zeigler denied ever telling Odom about the ski mask bandits, describing the layout of the store, or providing any diagrams or photographs of the store to either Odom or Thomas. Zeigler had to admit that he had no good excuse for how Odom found out about the ski mask bandits, or how he would have known that Daniel Thomas, one of the ski mask bandits, would be a good fall guy. Relevant legal standard. The Florida Supreme Court's guidance about cumulative analysis is closely linked with the Jones test. A trial court must consider whether newly discovered evidence is of such nature that it would probably produce an acquittal on retrial. And that, of course, is still quoting Jones. The trial court must assess the likely result that would occur during a new trial, with all admissible evidence at the new trial being relevant to that analysis. And that's referencing Swofford v. State, Florida 2013, and Hilden v. State, Florida 2014. A trial court may grant a new trial only if the trial court concludes the net weight of the newly discovered evidence weakens the case against the defendant so as to give rise to a reasonable doubt as to his culpability. And that's referencing Jones, quoting Jones v. State, Florida 1996. Yeah, they used this in their closing argument, so this does sound familiar. And I'm sure you guys, if you guys listened to that or read that, it sounds familiar to you too. When conducting cumulative analysis of the evidence, it is appropriate for a trial court to independently weigh the credibility of witness testimony. Hitchcock versus State, Florida 2008, noting that witness credibility is crucial to the newly discovered evidence analysis. And that's referencing Jones, explaining that it is the trial court's responsibility to assess any inconsistencies in the newly discovered evidence. Argument 1. Zeigler's confession rebuts one of Zeigler's central vectors of attack on his culpability. When a defendant confesses to committing a crime that is weighty, sometimes depositive evidence of their guilt. Here, Zeigler's confession not only serves as a direct evidence of his guilt, but it also provides a more complete picture of why he murdered his wife and in-laws. Since his initial trial, Zeigler has been complaining that the state's argument about his motive for killing his wife didn't make sense because he was a wealthy businessman and he supposedly didn't need the money. Zeigler's confession reveals that purgatory gain was not the sole reason he killed his wife and in-laws. He also did it to protect his prized reputation. The tragic murder of his wife at the hands of some ruffians, unlike a reputation-destroying divorce, would help preserve Zeigler's standing in the small community in Winter Garden. A jury already convicted Zeigler once, knowing only half of the story. There is no reason to believe a jury would decide differently if they were presented with the full picture. Well, I disagree, because there was just so much that wasn't there, 40, 50 years ago, that I believe the jury would probably be either a hung jury or, they would have a hard time convicting him. I really think that would be true. But again, that's my opinion. 2. Odom's theory is more credible than Zeigler's. When comparing Odom's story to Zeigler's, Odom presents the simplest, most rational explanation of all the evidence presented during the resentencing hearing. Zeigler would likely suggest that Eddie Odom is not a credible witness because Odom is a convicted felon. He might quibble with Odom's denial of various bad acts that Zeigler accused him of committing, and he will most certainly say that Odom was just saying what the state wanted him to say to get a favorable clemency recommendation. Even if a jury were to accept all those criticisms, Zeigler's story, in contrast to the one Odom told, could not explain away the unflattering evidence. Zeigler initially tried to claim he didn't help Odom create diagrams nor provide him with any photographs of the scene, 1989. Zeigler then admitted he did draw one of the diagrams in State Exhibit 5, but claimed it was for a synopsis he wrote shortly before getting onto death row for some unknown audience with an unknown purpose. Zeigler had no explanation for how Odom obtained this diagram, nor how Odom obtained photographs of the crime scene, nor how Odom accurately annotated the location of key evidence on these photographs. Zeigler had to admit he authored a letter which provided a detailed confession to the murders, but he claimed the letter was really from an approximately 1,180-page book. Despite having a keen memory of other matters from 13 years ago, Zeigler conveniently could not remember a single word he wrote in that book. Zeigler also suggested Odom must have gotten a copy of the book because it was confiscated in 1980, but the state pointed out that the state's investigator received the letters in 1979. Zeigler speculated that Odom must have gotten details about Zeigler's case from an unspecified detective magazine and from his wife because Odom said she was a friend of one of the court reporters at Zeigler's trial. As to this unspecified detective magazine, Zeigler admitted he had never read it, did not have a copy of it, and had no idea what was included in it. Curiously, Zeigler's attorneys made no attempt to cross-examine Mr. Odom about having any detective magazines, nor did Zeigler explain how Odom's wife, let alone her husband, gained access to Zeigler's trial transcript. Additionally, even though Zeigler's attorney had deposed Odom's wife, she was never called to testify about what she knew, or that she was, at the very least, aware of the contents of Zeigler's trial transcript. So, were the trial transcripts not available back in the 70s or 80s? I mean, obviously, this resentencing trial was 1989. So I would think that they would have been available, obviously not as easily as we can today on a computer, but, they could have probably looked them up, right? I mean, it's public information. I mean, remember the old microfiche? Some of you guys remember that. 3. Zeigler's self-admitted participation in a plot to frame another person for the murders confirms his culpability. Even if a jury completely bought Zeigler's story, Zeigler still admitted to actively participating in a scheme to have someone else falsely confess to the murders, and that he would have seen the scheme through to the end if the price had been right. Just the submission alone seriously undermines Zeigler's chances of acquittal upon a retrial. I admit that it is bad that he went through with it. I mean, I think that he admitted it was not a good thing. Zeigler's self-admitted participation in a plot to engineer a false confession mirrors the level of scheme Zeigler engaged in during his original plot to murder his in-laws, then blame the murders on unsuspecting African-American males in the community. Much like his original murder plot, Zeigler invented clever excuses to explain away all the unfavorable evidence about his participation in the false confession scheme. And like his original plot, his excuses failed to withstand even the most cursory interrogation. From day one, Zeigler has blamed nearly every possible person for what he did on Christmas Eve in 1975. To this day, Zeigler insists, with little to no forensic evidence to support his claim, that Charlie Mays, Felton Thomas, and Edward Williams somehow participated in the murders. The total picture that emerges from the admissible evidence is that Zeigler has been desperately trying to blame everyone else, but all the evidence keeps pointing back to one guilty party, William Zeigler. Then how do we explain the DNA and the blood spatter? Come on now. Conclusion. Zeigler's confession to murdering his wife and his self-admitted participation in a plot to frame someone else for the murders seriously undermines Zeigler's chance of acquittal on retrial. Therefore, the state respectfully asks the court to deny Zeigler's motion. And that's signed Joshua Snow, Assistant Attorney General. Well, so that's the state's response. And yeah, if you hadn't heard about the whole homosexual portion, where Tommy, it's been alleged that Tommy killed Eunice because of that. Well, there you go. But I had heard that one before. Again, there's so much more to this. And I agree with the defense. It's not really relevant. The evidentiary hearing was to show evidence. Yes, we use in this country that we use inmates as witnesses. It happens all the time, every day. And they of course get different sentences. They get upgraded, other privileges, whatever. From the state to testify against, another person. But you have to like figure, people will lie and go with stuff to get the best for them. So, I mean, I don't know how credible this Odom guy is, and I have to say, as bad as it is that Tommy participated even a little bit and agreed to it, let's just say he agreed to it, which is what Tommy said, to get somebody else for the right price to do this because he was desperate, which again, I understand the desperation, because at that point, he thought, what, he's screwed. Everything that happened to Tommy, he was screwed. I mean, they pretty much immediately circled in on him, and that was it. So he was desperate, and desperate people, do desperate things. And, I don't blame him for it, but does it look bad? Of course it does. I mean, it does look bad. But, what kind of criminal histories does this Odom guy have? I mean, I haven't looked him up because obviously I just heard about him here. But I'm pretty sure he probably has a lot more criminal history than Tommy did and does. So I think his credibility is probably not very good. But again, this is the state trying to take anything that they have and throw it on the table, because they don't want Tommy to have any chance of being exonerated or having the judge say, hey, there's a question as to your guilt, which there totally is a question as to Tommy's guilt. A lot of questions as to Tommy's guilt. Need I bring back up that the judge got the doctor of the one juror to give her medication, and the judge didn't, like Tommy. They had some history, and the judge did not take the jury's recommendation of life and gave him the death penalty. So that's not even everything. That's just what happened at the trial in 1976. So, yeah, there's a lot going on with this case, and it's a sad thing that I think that Tommy has been locked up for the majority of his life, for something that I still don't believe he did. Just because you made some bad choices while you were in prison, when it comes to something like that, where you're just like, hey, I'm desperate to get out. Yeah, I mean, it's going to be on his record, and he knows it to this day. He knows that that's not going to go away. But he did come out in 1989 and say, you know what? That was stupid. I shouldn't have done it. I did it. But no, he has refused to admit that he ever killed his wife or his in-laws, because I don't believe he did it. I believe him when he says he didn't do this. And the evidence, the DNA, backs up what Tommy says. But again, let me know you guys' thoughts in the comments. And we are waiting, I guess, to see if anything else pops up on the court website, as far as on the clerk site. And if not, we'll be waiting still for the judge decision. And yeah, so we're going to keep Tommy and this case in your thoughts and prayers. With that said, I hope you have a great rest of the day. And most of all, stay safe.